Recording.
Yep.
This is docket 262798FH, People of the State of Michigan versus Jaden Allen hyphen Damicho Gonzalez. Counsel, your appearance for the record.
Good morning, Your Honor. APA Barb Buxton on behalf of People of the State of Michigan.
And good morning, Your Honor. Frank Harrison, Ingham County Public Defender's Office, here on behalf of my client, Mr. Gonzalez, who appears in person and standing to my right.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
Yes, ma'am.
Is it anything that interferes in your ability to understand your attorney or the court?
No, ma'am.
And is there medication you're supposed to be on that you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
And have you had enough time to speak with your attorney?
Yes, ma'am.
All right, thank you. And what are we doing here today, counsel?
Thank you, Your Honor. I think I could start here, Your Honor. So this is a bond motion that I had filed sort of in conjunction with client's previous attorney, Miss Andrea Lacey, of also the Public Defender's Office. My understanding of Your Honor is from notes from Miss Lacey, basically saying that Your Honor was going to consider releasing my client on a PR bond if basically his mom was to accept him at his house. That there was an issue with mom saying that she didn't want client there because client was around drugs. I have spoken with my client's mom, and my client's mom is willing to take him back underneath the auspices that my client is off the drugs. And my client understands that as what's happening here today. And that's more or less where the motion comes from. My client's mom is willing to take him back. My client's mom understands that he's right now not doing drugs.
You've got to slow down.
My client's
sir.
mom is willing to take him back. My client's mom.
Sorry,
It's okay.
my sincere apologies. I know I should speak slower. I just get in a habit. But I spoke to my client's mom, and she's willing to take him back as of today. And understanding is that as long as my client participates in all the things he needs to with the court, that he's going to seek treatment upon his sentence in early August in front of Your Honor. And on top of that, he's currently participating in the CATS program right now in jail. So what we're hopeful for Your Honor today is that Your Honor will grant him that PR bond so he can stay with his mom and potentially deal with his Livingston matters, where he has 2 outstanding warrants over there. Livingston right now is not willing to arraign him on those matters until such time that either A, he's sent to treatment, or B, he's given a PR bond in this file. I don't know why, but that's Livingston County's position. So we're hopeful that Your Honor will help facilitate that movement as well.
Well, let me ask you this. I don't have, because this was not a drug case, but what was his drug of choice?
Meth.
Meth? So why are we not sending him to a meth-specific residential treatment program first, and then from there he goes to mom?
If Your Honor was willing to do that and send him to rehab today, we'd be willing to do that. But
Meth grabs you by the throat and doesn't let you go.
that's correct.
And I suspect his family would like to see him alive, not dead, and recovering, and I hope that's his goal. And that's exactly why Livingston County is doing what they are doing. And I think he needs to be on the road to recovery before we actually release him. Even though his mother's willing to take him, that would be clean and sober. And I appreciate your mother coming from that stance, because she truly loves you. And that's what happens. You can't simply support your child in everything. Sometimes you have to take that hard stance and say, go to treatment, then you're welcome home, because that saves lives. So don't hold that against her, if that's even a thought. She's doing that because she wants her kid back, alive and well.
Yes, ma'am.
So in regard to this, because we're going to sentencing soon, I'm gonna sentence him to rehab anyway, why not get a jump on it now?
I would be entirely on board with it. So is my client. He wants to go to treatment, Your Honor. So if Your Honor would do that, then we are more than happy.
Well, let me hear from the people.
Your Honor, I was originally concerned if he was going to be released straight to his mom, but if he is going to an inpatient center to deal with his meth problem, the people would have no objection to that.
So I'm gonna order that. My issue though, counsel, is that he may have to be transported, or they can do it by Polycom or Zoom or whatever, to Livingston County. I'm not sure about all of the rules. I don't run all the programming, sometimes I wish I did, but I'm guessing that they might not accept him with the warrants, and what will happen is he'll be out of treatment, supposed to go to his mom's, then be transferred to Livingston, which means he could backslide, because that's kind of counterproductive. So I'm wondering if we can work out, I'm gonna do some alternative orders, so that if he can be arraigned by Livingston, to get rid of those bench warrants, then he can go to treatment, and I suspect if you contact the prosecutor there, they would agree. Because it sounds like we have a common goal of rehabilitation. So I'm gonna do some alternative orders in his best interest to answer all of these issues. Does that make sense?
That makes perfect sense, Your Honor. We do thank Your Honor.
And on behalf of the people, I think that's the best way to go. Are you all right with that?
That's fine with me, Your Honor.
And sir, do you understand?
Yes, ma'am.
Okay, so I don't know all the rules, but I do know in certain situations you can't be placed there because of warrants. So it might be that you're transferred to Livingston, then from there they agree with this tough love approach where you go into treatment, and then they'll remove bench warrants and then deal with whatever they have to deal with then, or maybe when you're clean. And what is your mother's address?
5913,
5913?
South Waverly, apartment H, Lansing, Michigan, 48911.
Apartment H?
Yes, ma'am.
So when is our next court date? Do we know?
Yes, Your Honor, it is August 5th, I believe. Yes, August 5th at 11.
That is correct.
So, sir, if you are in treatment, are you in agreement with being sentenced on Zoom? Otherwise, we can have you brought here before this court. It's up to you.
Yeah, I'm gonna do it on Zoom.
Okay, so what will happen is during the hearing, you'll be able to talk with your attorney in a confidential breakout room. And if that's needed, and you'll be able to talk with them beforehand, you'll have to review the pre-sentence investigation report. Have you already met with probation? Right. Okay, so that's unusual. I don't know why. I mean, you've been in lockup, they should have seen you, so they'll have to talk with you through Zoom. If they don't contact you, we'll have to move the sentencing, because we can't proceed, and I'm surprised they haven't. We need to probably check on that.
Yeah, I was unaware that PSI had, or the pre-sentence investigation hasn't happened. I will see what I can do about greasing that wheel.
Okay, and if there's an issue, it doesn't really matter, he'll be in treatment probably 90 days, so we can move it out. And apologize that they have not contacted you. Usually they do, but I don't know what's going on there. All right.
Something they judge.
It's August 5th at 11. Do you have 2 bench warrants in Livingston County?
Yes.
Counsel, are you in contact with his Livingston County attorney?
I'm not actually in contact with Livingston County attorney. I'm not aware who it was. There is some contact information I've had from people that are trying to coordinate all of this that I'm in
Okay.
contact with.
Okay,
I'll give you the name of your honor here in a second.
well, I'm gonna read what I've got, and then let's amend it as we need, okay?
Okay.
So I'm giving him a $25,000 PR bond upon being accepted and entering the MES-specific long-term residential treatment program. He'll be placed on a jail GPS tether upon release from treatment, and then we'll talk about how long that's going to be. You need to make sure you're doing well. You will not use, possess, consume, purchase, or be in the presence of any illegal drugs, alcohol, or drug paraphernalia. You will show all prescriptions for medications from a licensed medical physician of pretrial services within 24 hours, and take any psychotropic medication as prescribed, follow all doctors' recommendations. Those become orders of this court. You'll sign all necessary releases, so we can verify that you're doing what you need to do in this program and any other treatment that you're doing, okay? We don't ask what you're talking about or anything personal like that. We don't violate it, but we just want to know, are you getting out of bed, participating, doing what you need to do, following all recommendations? Does that make sense to you?
Yes, ma'am.
All right. You'll PBT and drug test as requested by pretrial services, law enforcement, any court officer, or your mother, and follow all aftercare of the treatment program. And the PBTs and or drug test will be 3 times per week and random on weekends. So that would be Monday, Wednesday, Friday, so you'll know when they're coming, and then random on the weekends. That way we'll catch you. But you can also arrange your schedule if you're gonna be working, so you know when you're doing everything, and then random on the weekends. And this is a schedule that if you're still using, you think you can cheat us, we'll get you, and you'll be back in jail or prison to save your life. Tough love saves lives.
Yes, ma'am.
And we'll then taper that down once we see your sobriety, your engagement, your success, and then you'll earn everyone's trust, your mother's, the courts, the public's. Understand?
Yes, ma'am.
All right. You will not own, have in your possession or under your control any weapon, gun, ammunition, imitation of a weapon, and not be in the presence of anyone who has those items. You'll not be in the presence of any known gang members. You'll not wear any gang colors, insignia, or gang tattoos. You will, upon completion of the residential program, unless you're transported to Livingston County Jail, I don't know what they're going to do, I have no control over that. Maintain your residence with your mother at the South Waverly address. And any change of address must be approved by the court. You'll appear for all hearings and proceedings. Your next court date is the August 5th at 11 p.m. or 11 a.m. unless we get it moved, because I'm concerned about that PSIR not being done. So your attorney will be in contact with you. You will be transported by the Ingham County Jail or picked up by Livingston County for the bench warrants and arraigned, and then be transferred to residential treatment. Okay? And is there anything else I need to order that I have not?
I don't believe so, Your Honor.
So is there anything I have failed to address?
I believe you've addressed everything, Your Honor, and I appreciate that Your Honor has given us the tools necessary to facilitate getting Mr. Gonzalez into treatment.
All right, so let me ask you one other thing. How old are you?
22.
Okay. So at 22 years old, you've turned to meth, and possibly other drugs, and you can get the meth. I understand how all this works. Why did you want to check out? Did something happen to you? Are you suffering from grief, or were you self-medicating because of mental illness, or were you abused, or what happened where you decided things were so bad you needed to check out? Do you know? Is there anything? You don't have to tell me what it is.
I was just self-medicating.
Okay. And so now you're on medication that is working?
Yes, ma'am.
Okay. All right. Did you have physicians you're treating with community mental health, or?
Yeah, I've been talking to community mental health.
Okay. So I'm also going to order continued mental health treatment and working with CMH or other doctors or agencies as recommended. I think that covers everything then. All right, sir, do you have any questions?
No, ma'am.
So then we'll talk about the sentencing, this will be incorporated into sentencing. And have you ever held a job?
Yes, ma'am.
And what did you do?
I was at McDonald's.
Okay, did you graduate?
I got my GED.
Okay, are you thinking about college?
Yes, ma'am.
What do you want to do?
I want to become a welder.
A welder? Okay, so remind me at sentencing, because I want to even know, because we should probably order that he get into trade school and or college at LCC. You can get free college, they have a great program. Because that will also help with your mental health, your focus on life, and all the good things that are offered, instead of sinking down into meth, okay?
Yes, ma'am.
All right, so this is for you. If you want to throw it back at me, the prison is also for you. Any questions? All right, we're gonna make you copies of this, and I will see you in August or as soon as we can, all right? And then we will sentence on, I'm just gonna make a note, sentence, Zoom from facility. And council, please let me know where he's at, because I don't run Livingston County, and maybe they'll house him for a while before they send him to treatment. It sounds like they don't wanna waste money on their jail anyways, or either, if we can put him in treatment. So if you can convey that, maybe send a copy of this. It's not the best handwriting, or, well, the handwriting I think is legible, but there's a lot on here, so if anybody needs interpretation, we'll get it. All right, anything else?
All right, thank you, Your Honor, for today.
Good luck to you, son.
Here and so.
Bowers next. But that's the best.
I understand, okay.
This is he coming out?
Yeah, sure.
Oh, all right. This is docket 256724 FH, people of the state of Michigan versus, is it Carvante?
Yes, ma'am.
All right, Bowers, counsel, your appearance for the record, hands on pocket for safety reasons, sir, thank you.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General. Good morning, Assistant Public Defender Senator Donnelly, on behalf of the defendant, Carvante Bowers, who is standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and comes to perjury?
Yes, ma'am.
Thank you. Put your hand down. And, sir, you taken any medication yesterday or today?
Taking a painkiller for my tooth.
All right, does that interfere with your ability to understand the report of your attorney?
Mhm.
All right, and you feeling okay except for that pain?
Yes, ma'am.
Is there medication that you're supposed to be on that you have not been on?
No.
And have you had no time to speak with this gentleman?
Not really, no, but
Go back and talk, counsel, you know when you're ready. All right,
we can't keep speaking.
What do you
She doesn't
mean?
let me speak.
well, she didn't let you speak, I don't know what, is there something publicly you wanna say? What do you mean she doesn't let you speak?
She cuts me off, she curses me out. and
Okay,
I don't want to keep moving forward with something like that.
are you telling me you can't get through this case with her, there's a breakdown of communication you want them aware?
Yes.
Okay, so you are facing child support that you pay count one. I don't know what the situation is here, but there's an allegation that you failed to pay over $30,507.47. That was in December. What is the number now?
$45,069.28.
Okay. Sir, are you working?
Yes.
What do you do?
I'm an auto detailer.
Okay, so you're making pretty good money?
I make about $300 to $400 a week.
I'm surprised it's that low. That's a specialty that you have.
Yes.
Okay, so are you paying child support through your employment?
Yes.
Okay, so why is this climbing? Is child support too high for you?
Yes.
Okay, so let's start with this. It appears to me, well, I don't want it to appear to me, let me just ask you a specific question. When was the last time you had a review of your child support?
Never had one.
You never had one, okay, so here's the deal. The law does not reward somebody for sitting on their rights. By law, you are entitled to a review of your child support every 2 years. If your child support is too high because life happens and you switch jobs, etc., then you let the friend of the court know they recalculate child support. Child support does not go backward, but it can be amended forward, okay? And so it goes from the date you request. So if you go downstairs today, fill out, I don't remember, it's a pink, blue, or gold sheet. It's been 20 plus years since I practiced family law, but there's a sheet, you just request a review of child support. From that day, like from today, it'll be reviewed, and the amount you have to pay will be less, because you've got quite an arrears here.
Yes, ma'am.
So I don't know what your defense is, if the number's wrong. But if your defense is that you simply couldn't afford to pay, that's not a defense because you sat on your rights. I don't know what conversations you've had with Ms. Donnelly. There's a presumption of innocence until proven guilty beyond a reasonable doubt. I don't know anything about this case, but essentially, that's where we are here in the child support case. So I can give you time to speak with Ms. Donnelly, I can get you another lawyer, but this case isn't going to change. Is there some questions that she has not answered that you think I can answer for you?
No, man, we're just like another attorney.
And Your Honor, I explained to him, some of his concerns are with the underlying civil matter. And I explained to him that those challenges will not be brought up here in a criminal trial, that the law precludes those things from him collaterally attacking the underlying order. And so that's what I've tried to explain, and I think his counsel's trying to explain that some of his concerns are that aren't properly addressed
So,
in the
sir,
criminal matter.
Thank you very much for that. What are those collateral issues? What's going on in civil court? Are you complaining about the amount?
No, it just came to my understanding when I was going through the files. I was served on February 6th, but the summons and complaint was issued to May 2nd
For what?
for this case.
No, for the child support case in 2014.
Oh, not this case. I guess I'm being confused because this case is different than.
Okay, so let me understand this. So he got an order to appear in family court?
Yes,
He's been ordered to pay since 2014?
yes.
So why have, the order's been there by judge, you've had access to the judge, why didn't you complain? Okay, I mean, I don't have to do this, I can't give you legal advice, I want to understand the lay of the land here, because I think you're a bit confused.
The reason I'm bringing it down because I only discovered this apparent discrepancy after reviewing the court file.
So wait a minute, sir, that you're mumbling, I need you to enunciate and just start over.
I am bringing it now because I only discovered this apparent discrepancy after reviewing the court file. Once I saw the proof of service and the summons appeared to have conflicting dates, I acted to bring it to the court's attention.
Had conflicting dates, I what?
Conflicting dates, I acted to bring it to the court's attention. I'm asking the court to determine whether the case was properly commenced.
Well, how many children do you have?
I have 3.
And the child support is under this docket for all 3 children, that would be 14-1383 DP.
No, ma'am. 1 child.
Okay, you have 1 child under this,
Yes, ma'am.
okay, are you paying child support on the other 2?
No, ma'am.
Okay,
There's no child support case with the other 2.
okay, so this is all deals with 1 child.
Yes, ma'am.
Is your name on the birth certificate?
I think so.
What do you mean you think so? Were you at the hospital and signed the paperwork?
I just don't remember signing it or not.
Okay, well, here's the thing. Do you see this child?
Yes.
So the law is, even if your name is not on, you're a putative dad, you act as dad. There's another part of the law that says that if you acted as dad and you have not fought this, then you are dad. And there would not have been an order by the family court in any way, shape, or form against you unless you were a lawfully dad under one statute or the other. So by knowing you have this child, you must pay child support. So I don't understand where the discrepancy is.
Summons and complaint was filed after I was served.
So what?
So
You have to be served and then it's filed, but it doesn't matter. So here's the thing, you show up in court, you've availed yourself of the jurisdiction of the court. But that is a flaw that is irrelevant. So you can fight irrelevant portions of the law, but I want you to understand the family court does have jurisdiction and there's no one in the state of Michigan, no lawful or licensed attorney is going to tell you any different.
I never showed up to court for it to send it to the jurisdiction.
I never showed up to court for what?
For the summons and jurisdiction, okay, but you've been ordered to pay child support,
Yes,
and
ma'am.
so there was a default, and there was probably a default, and you ignored the court, and they properly served you probably in 2014.
Yes, I was served on February 2014, and I come to find out that they didn't follow the court rules.
But, and what he doesn't understand is that doesn't matter, that error was cured by his further involvement in the civil matter.
Yeah. That is not a
What does that
viable.
mean?
It means that once you participate in any way, shape, or form, you are acknowledging, regardless of the flaw, you are acknowledging that the court has jurisdiction over you. And that you had notice of this.
I have to participate under duress, there's nothing else I can do.
Okay, but regardless, you participated. You did not have to, you could have gotten a lawyer, you could have objected then, without finding an answer. There's lots of ways to do that, and then they just would have cured it, and it might have saved you a week or 2 or 3 of child support, but other than that, no.
I have one more question.
Yes,
Is there a law that states that at any point in time, once I find this evidence, which I do have, that it cannot be challenged?
yes.
What law is that?
Well, there are lots of them. There's a book that's just like this. This is the criminal law one, there's a family law book. You go to your local library and find it, I'm sure. It says family law. I don't know what color it is this year. But it has all the statutes and the court rules. And under court rule, once you had notice of it, and you participated, you can't go back, and there's a time frame of time in which you can, and you can't claim error, and you can't claim mistake, because you knew you had a child and you engaged with this child, and you've not fought about paternity and all of that, which passage of time is huge. There are all sorts of, not just court rules, but case law and statutes. There's also a family law bench book that I am certain is probably in the library as well if you want to do your own work, but I don't think that you have one viable claim, not 1% of a claim. I don't see it here, sir. I can't give you legal advice. I've not seen any of the paper, but I want you to understand this criminal action is going to stand, even if you fight in the lower court. The amount may change a little bit, I don't know. But you are at least $45,000 in arrearage, and it continues to grow. And it sounds to me like you're overpaying based on your income. So you need to take some action. Right now, you're sitting on your rights. Go downstairs, file a claim for review of child support.
I need to do both.
What?
I need to do both.
Well, do whatever it is, you can do that downstairs, but this case is going to stand. So I can get you a new lawyer, but there's not a lawyer in this county or in any of the, 83 counties in Michigan who can help you on this issue.
Yes, that's something I have to do myself.
Well, yes, downstairs, but even here, I don't think Ms. Donnelly has given you advice that's anything different than what I've said. So do you want some time to talk to her? You want a new lawyer?
It's more than that,
Okay,
which I already told you.
so she's not listening?
I can't get the word out. She's not listening to me. She's cussing me out, and it's just more to it. She treats me like nothing, so I don't want to.
So how is she cussing you out? I have known her for years and years. I've never, I have sort of a military potty mouth. I try not to use that on the bench, but I've never heard her do that.
She went out in the hallway, and she said, come back in here. I don't want to hear this dumb shit. Like, what?
All right. It is the public defender's policy to not issue you another lawyer from their office. So I will have to give you conflict counsel. I'm assuming you can't with this arrearage afford an attorney on your own, so I'll have to give you court-appointed conflict counsel, and you'll have to work with them.
Okay. Is that
All
the only
right.
option
Ms. Dunn, if that's your only option,
for attorney? Or at least I can.
you can represent yourself. I don't think it's gonna go very well. You're not apprised of the law. I feel like you don't wanna believe me, which is why I have spent some time with you. Got a lot of people waiting, but I want you to understand that this isn't gonna go away, and you do have rights. And it sounds like you understand you have a constitutionally protected right to parent your child and to raise that child, and you've been doing that.
Yes.
But you also have been sitting on your rights, so you need to tell the friend of the court about that, fill out the sheet today before you go, give it to them, and who's your judge?
Right downstairs. I can't remember,
Male,
Judge Kara?
female?
It's a female, I think it's Judge Carol or something like that. No, not Carol.
Katie? Judge Katie?
Yeah.
Okay. Well, so there'll be a hearing, and she'll listen to you, or a friend of the court will first, and then she will, I don't know what her policies are. But, this case isn't gonna go away, like I said, the amounts may change, but once you get over $5,000-6,000, the Attorney General's office is, very good at, filing cases against people who don't pay child support.
I understand.
Okay, your child support is an obligation of the parents, both parents, and the right of a child. Do you understand that?
Yes, ma'am.
Okay, counsel?
Your Honor, do we want to reset our final pre-trial?
Any other questions you have?
No, ma'am, I'm gonna take your advice and do two things on the session.
Yeah. And then you need to work well with your attorney, and we need to get this resolved, sir. Okay,
Yes, ma'am.
all right. Hopefully this recommendation is
Thank you, Judge.
Good to go.
good to go.
We're gonna do Ricky Norris next.
Did you see Mr. Gary's,
Let's see what.
oh, it's fixed now.
Yeah, I meant to put Mr. Catling's client in the breakout room with him. I actually moved to the courtroom instead. That's
Oh,
why it came back and said recording in progress, because I was hit the wrong one. Morris.
Right, Your Honor, if I approach, I have a plea agreement and by circuits.
All right. All right, this is docket 256470 FH and 255997 FH. People of the state of Michigan versus Ricky Dwayne Norris. Counsel, your appearance for the record.
Good morning, Your Honor. APA Barb Buxton on behalf of the people of the state of Michigan.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Ricky Norris, who is standing to my right.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand up. Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No,
Any sign of fever, COVID, or other illness?
no,
Have you had enough time to speak with Ms. Donnelly?
yes.
And how are we proceeding, counsel?
Your Honor, we have a plea agreement on both of these files.
All right, sir, you discussed the plea agreement with your attorney and you're ready to plead today as soon as we go through all the questions I've asked you.
Yes.
All right, and what is that agreement?
Yes, Your Honor, the defendant be pleading in 25-6470 FH to the case in its entirety, that being a resisting and obstructing a police officer, which is typically a 2-year felony. However, there is a habitual offender second attached to it, which would then make that 3 years maximum, Your Honor. Upon successful plea and sentencing, 25-5997 FH should be dismissed in its entirety.
And any restitution, if any, would then be transferred on to the 25-6470 FH?
Correct, Your Honor.
Do you agree with that?
Yes,
All right, is it full, fair, accurate, and complete?
yes,
Full, fair, accurate, and complete, sir, the agreement that was just outlined?
Yes.
All right, and sir, are you a US citizen?
Yes, ma'am.
And let me get to this file. Do you still reside on Illinois Avenue?
Yes, Your Honor.
All right, who lives there with you?
My grandfather.
All right, are you still welcome back in the home?
Oh, yes.
And the offenses that you are pleading to, were you on probation? Were you on parole or bond conditions with another court?
Off on bond
With this court or another court?
with this court.
Okay, thank you. And is that on the other files being dismissed, counsel?
yes,
All right. So any violations would also be not charged or withdrawn.
Correct, Your Honor.
All right, great, thank you. Then counsel, you are waiving reading docket 255997 FH, including any violation in their entirety.
yes,
Okay, as to then the counts in docket 256470 FH.
Yes, Your Honor. People of the state of Michigan versus Ricky Dwayne Norris. State of Michigan, County of Ingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date, not the location described below, the defendant in count 1, police officer, assaulting, resisting, and obstructing. On or about October 25th, 2025, at 420 South Grand Avenue, Lansing, Michigan, 48933, Ingham County, state of Michigan, the defendant did assault, batter, wound, resist, obstruct, oppose, or endanger Andrew Armstrong and/or Thiessen Graham, police officers of the Lansing Police Department, and the defendant knew or had reason to know was performing his or her duties, contrary to statute. This is a felony that is punishable up to a maximum of 2 years and/or $2,000. A consecutive sentence may be imposed under MCL .506A, if the assault was committed in a place of confinement, or under MCL 750.81D6, subsection 6, for another violation arising from the same transaction. Habitual offender second offense notice. Take notice that the defendant was previously convicted of a felony or an attempt to commit a felony in that on or about September 26, 2023, he or she was convicted of the offense of police officer assaulting, resisting, or obstructing in violation of MCL 750.81D1 in the 55th District Court for the County of Hingham, State of Michigan. Therefore, the defendant is subject to penalties provided by statute. That penalty being 1 1/2 times the maximum sentence of primary offense or lesser term. The maximum penalty cannot be less than the maximum term for the first conviction. That would make the resisting and obstructing charge a maximum of 3 years. Court shall order law enforcement to collect DNA identification profile sample before sentencing or disposition if not taken at the time of arrest and against the peace and dignity of the state of Michigan.
Thank you. Sir, did you understand what was just read?
Yes.
So you understand police officer assaulting, resisting, obstructing normally a 2 years, because an individual is now 1.5 times, so it makes it a 3-year, it enhances it. Do you understand that?
Yes, Your Honor.
Did I ask you if you took any medication?
Yes.
And are you supposed to be on any kind of psychotropic medication?
No.
Okay. I'm just asking because I noticed at one point there was a note that, were you gonna go into mental health court or was that something else?
He was being screened but found ineligible,
No.
clinically ineligible.
Okay. Thank you. And sir, it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes.
Did you understand what you read?
Yes.
And if you had any questions about your rights, were you able to ask those of your attorney?
Yes.
And sir, are you choosing to plead of your own free will?
Yes.
Did anyone force, threaten, or coerce you to plead?
No.
Anyone promise you anything other than the plea agreement?
No.
And you chose to plead after you were fully informed and you discussed everything with your attorney?
Yes.
And you've been satisfied with the representation of your attorney?
Yes.
As to count 1, police officer assaulting, resisting, obstructing, how do you plead?
Guilty.
And surgeon understands that you are giving up your ability to have an automatic right of appeal. If you had a bench trial, a jury trial, and you weren't happy, the Court of Appeals must take up your appeal, but now it becomes their decision, and they will only take up your appeal if they think your issues are important. Do you understand that?
Yes, ma'am.
You're also, by pleading, giving up your presumption of innocence, your ability to cross-examine witnesses and any evidence that people bring, holding them to their burden beyond a reasonable doubt, etc. You understand all of that?
Yes.
All right, very good. And has anyone told you what I will do at sentencing?
Not at the moment.
Right, because they couldn't have. I'm sure your attorney went over options and you know this is punishable back to 3 years and there are a lot of options, but I don't know anything about your case. I'm going to know a little bit today, but when I'm fully informed at sentencing, then I'll make up my mind. Does that make sense to you?
Yes, Your Honor.
All right. Did this offense occur on or about October 25th, 2025?
Yes.
In the state of Lansing County of Hingham, State of Michigan?
Yes, ma'am.
At a specific location known as 420 South Grand Avenue?
Yes.
And did you come in contact with law enforcement?
Yes, Your Honor.
Were they in a marked vehicle?
They were the marked one.
They were in a marked one?
Yeah.
Did it say City of Lansing or LPD?
LP Lansing Police Department.
Yes. And were they uniformed officers?
Yes, ma'am.
And given the marked vehicle and the uniforms, you knew that they were working in their official capacity?
Yes, Your Honor.
And did they ask you to stop?
Yes.
Were you in a vehicle walking or something else?
Walking.
And did you not stop?
Correct.
What did you do?
I tried to run.
And did they eventually catch up with you?
Yes.
And you resisted them taking you to their custody?
Yes.
And did you, by doing so, by resisting, did you endanger Andrew Armstrong and or Tieson, Tieson Graham, Graham?
Yes.
And yourself and possibly others, do you agree with that?
Yes.
All right, and did you or any of them get hurt?
When I was taken down to the ground and tased,
Okay,
that was it.
okay. And you knew they were performing their duties?
Yes.
All right, and, sir, you were previously convicted of a felony or attempt to commit a felony in that on or about September 26, 2023, you were convicted of the offense of police officer assaulting, resisting, obstructing in violation of the statute in the 55th District Court, Graham County, is that correct?
Yes.
And so that's why we have the habitual second, which turns this from the 2 year to the 3 year. Do you understand all that?
Yes.
Okay. And counsel, do you have any question on behalf of the people?
The people are satisfied, Your Honor.
On behalf of the defendant?
No more further questions.
Our counsel or promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No.
As corporal, type of corporal.
You have, Your Honor.
Yes.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there's sufficient grounds to accept defendant's plea. Therefore, count one will enter with habitual second and dismissed in its entirety is 25-5997 FH, including any bench warrants or violations that were associated with that. And restitution, if any on that file, will transfer over to this file. It doesn't look like there's any from where I sit right now, but we'll figure that out at sentencing. Any outstanding warrants related to both files are hereby recalled and dismissed. Do we have a sentencing date?
August 3rd at 10 o'clock a.m.
Does that meet with your schedule, counsel?
That's fine, Your Honor. August 30th at what time?
10?
10 a.m. Thank you.
All right. Now, is there an issue of bond?
Your Honor, Mr. Norris has been in custody on the file he just pled to. My math is that he's got 252 days of credit on that. So, Your Honor, I don't know because we need to address it because Mr. Norris is intending right now to not do probation and do his time.
Right.
So if you're gonna do your time, you might as well just keep sitting and do your time. So, Your Honor, I don't think that we need to address bond at this point.
So how many days does he have?
I think, my math is 252. He was initially arrested and released like October 25th through November 19th or 20th. But then he was rearrested on December 2nd. He's been in custody ever since then.
Okay. What kinds of things you doing in jail?
Attending cats, Muslim service, and that's about it.
Okay. How far are you in cats?
Cats, I got my certificate for substance abuse disorder, and I'm still attending classes.
Okay, good. Well, we'll talk about what I do August 3rd, so keep go to those classes, because otherwise, I don't know if I'll keep you or release you, but I would like to see the progress that you're making, okay? On behalf of the people.
I just want to clarify, Your Honor, is it August 3rd or August 30th?
August 3rd.
3rd, okay. That seems like a pretty quick turnaround.
Yeah.
I thought it was the 30th too. Thank you for clarifying.
Well, he doesn't have much of a criminal history,
No.
so it probably will be fine if they don't have to do a 40-page PSR, so.
It might be enough.
Understood, Your Honor.
All right, so, sir, you'll have to cooperate with probation. I'm gonna come and see you. They're going to do a detailed pre-sentence investigation report, and then we'll talk about that at the time of sentencing. You'll need some time with your attorney to review that prior to sentencing. Do you understand?
Yes.
So right now, keep doing your programming and advise your attorney, and then the two of you can advise me of what you're doing. And then I'll see whether I keep you in the full year or release you then. It will depend on how well or how poorly you're doing, and if I get any reports of you fighting or doing anything in jail, that would go against you, but it sounds like I haven't heard anything about you, which means you're doing fine in jail. So just keep up the good work, all right?
Okay.
All right, thank you. It's all for the record.
Gary out? No. You can try.
Jerry Gary next. Ron Barry's on Zoom. You don't go over there, all right?
Do you need to talk to your attorney?
Jerry. No, man, I need to talk to him. He called me, he texted me yesterday. I told him I'm on the phone.
Okay.
Yes, ma'am. Carl Anthony, yes, ma'am.
Do we take him next or what?
I would like. to.
Can, Your Honor, that's an AG case, though.
Absolutely.
Oh, are we waiting for the AG?
No, the AG is on Zoom as well.
They're on, it looks like they're on
If we
Zoom.
want to handle that role, Mr.
Yes,
Jerry
let's
Gary.
do that.
I need to go bring up the file.
What are we handling first?
Carlos Anthony.
All right, we're gonna do the Carlos Anthony case. Thanks for raising that, sir.
Absolutely.
Do you wanna come up to the podium?
Right now, you're going to one more. Oh, sorry.
Sorry, we're gonna jump back and do what we should have done.
Your Honor, if I could get somebody to allow my.
Yeah, the law clerk's gonna allow it in just 1 moment. All right,
25,4,995.
No,
Oh.
23 case.
Oh, never mind.
all right, I'm just gonna call the case. This is, sir, if you could come up to the podium. This is 23-131 FC, people of the state of Michigan versus Carlos Anthony. This is an attorney general case, as I understand it. Counsel, your appearance for the record.
Good morning, Your Honor. Michael Doby, Assistant Attorney General for the people.
On behalf of the defendant,
Good morning, Your Honor. Ronald Berry. I am attending via Zoom.
Sir.
So great.
Sir, you broke up. Mr. Berry, we didn't hear anything you said after your name.
Thank you. I am attending via Zoom. Zoom is indicating that my video. I believe
Okay. I don't know why you can't do it, but my log will be in just a minute, and you are breaking up, so please stay by the microphone. I'm not sure what's going on with it. You can help Mr. Berry with his camera.
Yep.
All right, thank you. We got you, sir. All right, now, one more time. But stay by your microphone. We got you cut off at the end. I don't know why.
I'm gonna switch my microphone right now. Okay, this should be better. Yep. Are you able to hear me better now, Your Honor, without the echo?
Okay. So you said Ronald Berry on behalf of defendant on Zoom. Did you add anything else?
I did, Your Honor, but I didn't make it.
There is something wrong with your connection because we are only hearing syllables. Do you want to go out and come back in or what? I don't think it's on our end, but who knows? But the other attorney, Mr. Jogi, his was fine, so I don't know. All right, try it again. Unmute yourself. Yep.
Are you able to hear me better now, Your Honor?
Yes, much better. All right, Mr. Berry is here. Sir, are you in agreement with your attorney being on Zoom and you being in the courtroom?
Yes, he texted me, last night.
Okay.
And I'm informed with it already.
Okay, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. And sir, you taken any medication yesterday or today?
No.
You're supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
And you just said you had enough time to talk to Mr. Berry and you are in agreement with you
Yes.
being in two separate places. However, if you wish to speak with him, we can put you in a confidential breakout room. Do you understand all of that?
Absolutely.
All right, so I understand this is a final pretrial, is that correct, on behalf of people?
It is, Your Honor.
Okay, and what are was there a final offer made?
There's not been an offer made, Your Honor. We are looking for a trial date.
There's not gonna be an offer, there's just a trial date, is that correct? You're looking for that?
That's correct, Your Honor.
Okay,
Your Honor, just from the defense side, just a little bit of the history, just to clear and refresh the court's memory. This case kind of is a very old case, and there's been some discovery issues. It came out to like last time we were here for that were just never provided just certain discovery items to the defense, and then lo and behold, the assistant AG says that date of that hearing was back in February that he.
wait. Stop. Begin again where you say lo and behold.
On that date of that final pretrial conference, I believe we were back in February, that he had sent over stuff.
Wait, you missed some words. Did you get what he said?
I think so. On that date of that final pretrial conference, I believe back in February, that he.
That he what?
I don't know.
sent an email with a link to some additional discovery items, and which interestingly apparently were body cameras that were previously claimed to not exist. In any event, this case was dismissed on that day, has since got reinstated on motion to consider it. But Mr. Dovey yesterday had sent me a link with additional discovery items that had previously submitted, since they weren't downloaded or viewed since the case was dismissed. So
Wait, since, I think the court reporter needs you to go back to since. Is that
since the
right?
case was
Yeah.
dismissed last time, I didn't go through, continue to work the file. Did reshared again with you yesterday so that I had that done. Interestingly, again, as I said, there's 4 body cameras that were provided to me yesterday. So how it works is originally they provided me with 171 files.
Okay, stop. Where does he need to pick up?
How this was originally. There's 4 body cameras that are provided.
Yep, and they had originally provided me with 171 files. There was no body cam. So I kept asking for body cam police videos. It was told to me that, oh, it doesn't exist, it doesn't exist. And I said, then finally,
Okay,
then in November, there was to with 172.
okay, you went out. Then in September, what?
Then in November, there was 172 files in the link that was provided. So one additional file. That one additional file ironically turned out to be the interview of the defendant, which was very interesting. Timing, and that's the one file that suddenly gets provided. Then now we are up to 176 files. So there's been 4 more files that were added apparently since that final pretrial conference came to when it was dismissed, where I've been jumping up and down. I need police video. It's exculpatory. And so I have 4 police video body cameras that were added now to my files for a total of 176 files. But yet, if you look at the central dispatch log, there were 13 police officers assigned to this case.
How many
Not only-
do you believe that? How many police officers?
13 police officers, if you look at the central dispatch.
Wow,
I only have body
okay.
camera for 4 of them. Not to mention, I have no police video for any
For any
dash
what?
cam or rear camera or anything like that.
You said you have no, go back, you have no video
For the
or dashboard.
motor vehicle recordings. Then beyond that, what's interesting, incredibly, after all this time claiming that body camera doesn't exist, and even now the 4 body cameras I have been provided, those 4 body cameras are only when police officers arrived on scene to this party store, spoke with some of the witnesses, their accusers themselves. Is interesting, very informative and helpful. I'm glad that I finally provided.
Wait, very informative and
helpful for the defense. And I'm glad I finally got that. But again, there should be much more police video, because interestingly, what has always been provided in our discovery are screenshots from a body camera.
what's always been just provided, start from there.
Screenshots from a body camera of the suspect purported to be the defendant when captured. So how in the world do we not have that body camera if we have the screenshots, captured pictures from it?
Okay.
Then the vehicle is an important issue as to how that transpired. They clearly got the vehicle and took the vehicle back to CSI, but yet I have no police video of interactions with that vehicle when it was observed in its scene and then impounded. Preposterous. I can simply file a motion to compel, or we can get, one of the things.
Let's go back to, I can file a motion.
To compel, which I have, I'm gonna do now, because I'm gonna be asking for sanctions,
You don't need to file it right now, I'm gonna compel it, so, because I don't
and
know,
importantly,
we cannot charge people and then do discovery, we gotta do discovery and then charge people, so let me just stop you there. On behalf of the people, Has this not yet been provided? This case is 3 years old. What's going on with that?
Yes, Your Honor, as discussed at the last pretrial, as discussed in in my motion to reinstate, we have provided everything that I have and have the ability to get. Mr. Berry is correct that there was originally not any body cam provided. I had a new detective with MSP who searched the archive and was able to find these 4 videos that had not been properly tagged way back at the time, long before the Attorney General's office was involved in this case. We received those and those were provided. So the MSP has done a search of their archive. I provided everything that has been received by our office.
So, sir, have you reviewed them? Just a minute, Mr. Berry. Have you reviewed those?
Have I reviewed them? Yes, I've watched the
Yes.
videos.
Are they exculpatory?
No, Your Honor. They document the interviews that are also documented in police reports.
Okay, then let me just stop you there. So if there's what, 13 officers, isn't the law that they have to have those body cams on? And where are the rest of those reports?
Your Honor, I don't know what the other officers are, where the other cameras are. Everything that the current detective could find having to do with this case that was in their archive, he did provide. This is an old case. This is 2022. It involved Michigan State and Lansing police detectives and officers arriving late because of a shift change. I don't know all of the details of that. All I can say is I've asked the state police to review their archives, to come up with everything that they have. That's what I've received. That's what I've provided.
Okay, so again, this was in a liquor store allegedly. Was there any footage in the liquor store?
No, Your Honor.
Well,
So there were no
The victims did not. The
I would
victims,
tend to agree
despite
with
the
what
victims,
Just
despite.
a minute, Mr. Berry, I will address you, but we can't talk over each other. Otherwise, I'm gonna order everybody here and no more Zoom, because this is a sloppy record, and it's not for my benefit, it's for yours and defendants. So let me just ask the questions, and then you can jump in, Mr. Berry. So, Mr. Dobie, there's no cameras that were in the liquor store? Is that, or was the film not retained, or what?
The film was not provided to police by the owners of the liquor store, despite several attempts.
So was it erased, or we don't know?
I don't know, Your Honor. Again, that happened a long time before I was involved, but that is when asked specifically the detective, why don't we have video, said despite a lack of trying, they would not provide it.
Okay, we might have to have, and I don't know, Mr. Berry, where you're going with this, hear from you in just a second, but we might have to have some kind of evidentiary hearing to see and call all these officers and ask them on the record, where's the information, what steps did you take to preserve it, and all of that. I don't know, but I don't know if there's a Brady violation here or not. And so I think we need to establish that, given the voluminous amount of records and the information, 13 officers, you get body cam from what, 4, and then there's nothing from the liquor store. It might have been written over, I don't know, but I think we need to make an accurate record as we go forward in this case, or maybe we don't. I don't know, but if you're gonna make a Brady violation, which it sounds like that's what you're gonna do, then we need to have a very clear record about what did or did not happen. So now you may address the court.
Yes, I would just say that I think, I suspect Mr. Dobie is going to be correct in that they do not have any video from the party store. And I believe because they have non-cooperative witnesses that are actually engaged in criminal that don't
That are actually what?
engaged in criminal conduct themselves that didn't want the video to be seen. But in the event, that's not the responsibility of law enforcement if
It's the responsibility of law enforcement
if we're not able to get the party store to give it to them. The
So
bigger
how would
issue-
you like, the bottom line is, what would you like? Would you like an evidentiary hearing? You call them all, they take the stand and say what they do or do not have?
Absolutely.
We can set that up.
I think we should begin by the court ordering Mr. Dovey to obtain all audit trails for all digital media in this case.
I didn't get that, all
Audit trails, specifically when it comes to
audit
Axon,
trails?
they have audit trails that shows when the media was created, when it was accessed, when it was all that stuff. We need that for all media in this case.
Mr. Dovey, can you provide that, or do I can order that all of that be provided, and then we can do an evidentiary hearing and set this for trial?
Your Honor, I will contact the Michigan State Police and ask for those. I would like if I, before we start an evidentiary hearing, to at least have a motion or something so I know what it is that I'm responding to and trying to defend.
Yeah, we'll take care of all that. In order for this case to get moving, I don't want any more of this back and forth and being in front of me with allegations we don't have information. I think, Mr. Berry, if you could present, a request for whatever documents, I will order that whatever you request, they respond to. And then, within 45 days, you put that in order, I'll sign it, and then based on what you do get or don't get, please set an evidentiary hearing. You know, Nicole, my judicial assistant, set that in front of me. She'll give you the time to figure out if it's gonna be an hour or 2 hours, if it's 14 people or however many you need to call. It might be a whole morning or afternoon. Get that in my docket, and then also we'll get a trial date.
And then
Okay.
a report to be prepared by the officer who supposedly did this investigation, because I don't have that.
What this investigation?
Here's my
officer
issue. These are
You
Lansing
know,
police
this-
video files on Axon. I don't know why.
Just a minute, start over.
These are Lansing Police Department Axon files for their body cameras and body cameras. So I don't know what involvement Michigan State Police have in. I don't know. There's a disconnect there. Michigan State Police, with I guess when it comes down to the CSI, but for the body cameras and the motor vehicle reports, those should be on the Lansing Police Department.
Body cameras and dash cams, start from there.
As it relates to all the police video through Lansing Police Department on their Axon servers, that's something that should be done through Axon and through Lansing Police. I don't think that was.
Okay, here's my order. You prepare within 7 days a list of whatever it is you need, and you give that to Mr. Dovey. Mr. Dovey, you have 45 days to comply with that, or tell me why they can't. It might take, with so many records, it might take a little bit longer, whatever. Then the two of you get together with my judicial assistant and schedule an evidentiary hearing and stipulate to whatever issues. So Mr. Berry, you'll put whatever issues you want to put before this court in the evidentiary hearing, and Mr. Dovey, you put whatever issues you want me to look at the evidentiary hearing, so that you're both apprised of who's doing what and what you have to defend against or make a record of before this court, and whatever it is you want me to decide on. I also need you to get together on a trial date. It will probably be maybe March of next year at this rate. So I need you to get on my docket. This is one of my oldest cases. It needs to be cleaned up. So I think that's really the only way we can proceed today. And then all motions in regard to whatever we figure out will be filed. After the evidentiary hearing, I'll give you some time after that to file whatever motions, whether it's Brady violation or adding counts or deleting counts, whatever it is you want to do, so we can get to trial or get it dismissed or whatever it is, like to get some kind of agreement. I don't care how the outcome is. I'm no mistake in this, but we have to follow the rights of both parties for information and protect the rights of the victim as well as defendants. So I don't know how else to proceed unless we proceed like this. Is there anything you want to add, Mr. Joby?
No, thank you.
Mr. Beard?
What I'll just make clear for the record, so in the proposed order, the central dispatch log identifies the 13 units and the corresponding police officers' names. Those would be the ones.
Wait, identifies, you're looking at it again, identifies South Precinct log, identifies. Huh?
The vehicle unit numbers and their assigned. My order, proposed order will
Wait,
include.
somebody spoke again, the vehicle unit orders?
The proposed order I will prepare will refer to the any MVR, motor vehicle recording for those units and body cameras for those officers, as well as required diligence for any and all video.
Required for any and all vehicles. Sir, here's the thing, you're blipping in and out. I don't care what you need. You make a written list and Mr. Joby's going to comply and he'll make a list if there's anything he needs from you. You're going to have this exchange of information. Okay, so I don't know that we need to make a further record of it now, otherwise I need you to come in this court. It's way too difficult. I don't know if it's the way you speak or the connection. I don't know what's going on, but I think we need to be done with this for today and just make your written list, present it within 1 week to Mr. Joby. And then if there's some kind of impossibility or whatever, he'll respond. We can always fight that out. We can get me on the phone, we can come over on the lunch hour, we can make a further record if we need to, but in this court. Anything else we need to address? So you'll get the court dates from Nicole as well as a trial date. All right, and exchange that information, get me involved how I need to, and then just set an appropriate amount of time given the amount of witnesses. So whether it's a half day or a full day, we'll find it on my docket, okay?
Thank you.
All right, sorry.
Have a blessed day, Your Honor. Thank you.
Sorry about the technology.
All right, Mr. Berry, I love you, man.
That's all for the record. All right, thank you.
Oh.
Which one are we doing?
We gotta do this one first because he's on the DOC and I don't want to.
Okay, we gotta deal with MDOC case next.
Hold on.
Correct, Your Honor. Deshaun Joyner.
Huh?
It's Deshaun Joyner.
I don't want to interview. Jeez.
All right, let's start again. This is docket 26-1875FH, People of the State of Michigan versus Deshaun Lewis Joyner. Counsel.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Your Honor, Jeffrey Kaplan, P74943, on behalf of the defendant. We are both appearing by Zoom.
All right, and sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. You may put your hand on. Are you taking any medication yesterday or today?
No, ma'am. No.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
All right, and you're in agreement with proceeding on Zoom like this?
Yes.
And you had enough time to speak with your attorney?
Yes, ma'am.
So if at any time during this hearing you wish to speak to your attorney, let me know, and we'll put you in a confidential breakout room. Is that all right with you?
Yes, ma'am. Yes.
All right, counsel, I do have the felony information. I do not have a copy of the habitual. What is the habitual what?
There is no habitual, Your Honor. I apologize. I was informed by defense asking if I was dismissing the habitual. I was dealing with other matters, so I wrote we were dismissing it, but there is no habitual. at this
Okay, because
time.
I don't see it, so I'm simply writing that out in the form.
Thank you, Your Honor.
All right. And you agree with that, Mr. Kaplan?
I do, Your Honor.
Okay, thank you. All right. Sir, are you a US citizen?
Yes, ma'am.
And was this crime, whatever you're pleading to, which I'll see in just a moment,
Yes, ma'am.
were you on probation, parole, or bond conditions at the time?
Yes, ma'am.
And counsel, has he already been sanctioned for that or not?
I'm sorry, Your Honor, for the,
For the
I'm sorry,
probation or parole bond condition violation?
I believe he has already been sanctioned for that. Is that correct? Mr. Joyner?
Yes, sir.
Okay, so that's not gonna have any effect, all right.
Correct.
Okay, what is the plea agreement?
Yes, Your Honor. The defendant will be pleading in this case to count 2, unlawful driving away of a motor vehicle, as well as an added count 3 of home invasion in the 3rd degree. Upon successful plea and sentencing, count 1 will be dismissed. There's an agreement that the defendant will not seek HYTA as a result of this plea.
Full, fair, accurate, and complete, Mr. Kaplan?
Yes, except the HABs will also be dismissed.
So apparently there is no have.
Oh, he didn't have to, okay, yeah. Then
Okay,
that's accurate.
all right,
And I'm sorry, I should mention, restitution will also be required
Yes.
as determined in sentencing.
Correct, Your Honor.
okay, so restitution is still on the dismissed count.
Correct. I'm still waiting for paperwork from the victim on that.
So now is that full, fair, accurate, and complete, sir? Is that your understanding of the plea agreement?
Yes, ma'am.
Okay, thank you. And counsel, are you waiving reading count 1?
We are, Your Honor.
All right, as to counts 2 and 3.
Yes, Your Honor. People of the state of Michigan versus Deshaun Lewis Joyner, state of Michigan, county of Ingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date at the location described below, the defendant in count 2, motor vehicle unlawful dragging away, on or about June 14th, 2024, at 3584 Otsego, Okemos, Michigan, 48864, Ingham County, state of Michigan, the defendant did willfully and without authority take possession of and drive or take away, or did assist in, or was a party to such taking possession, driving or taking away of a motor vehicle, to wit, a Mercedes, belonging to another, to wit, Ahmed Mashi or Kelly Mashi, contrary to statute.
Okay, I need to stop right there. That is Dr. Massey, who is he's a neurologist and he also treats me. Is everybody gonna waive there? And also Kelly Massey is an attorney. I also know her. Are you waiving any conflict? I can be fair and impartial, but I need to disclose that I recognize those names.
Understood, Your Honor, that people would waive any conflict.
On behalf of you, Mr. Kaplan.
Yeah, I can't say that. Obviously, I have not discussed that with my client because we've just been made aware of that.
Yeah, and he's never mentioned that to me. I see him regularly for migraines, but we've never talked about that. So, sir, are you waiving any conflict?
Yes, ma'am.
Okay, did you want to talk to your attorney about that, or are you good with that?
No, everything's fine.
Okay, thank you. I haven't, this is a surprise to me, so I haven't talked to him, and it's not gonna influence me one way or the other. All right, so thank you. All right, now you may proceed.
Thank you, Your Honor. And then the added count of home invasion 3rd degree. On or about June 14th, 2024, at 3584 Otsego, Okemos, Michigan, 48864, Ingham County, state of Michigan, the defendant did break and enter or did enter without a dwelling located at 3584 Otsego Drive. And while entering, present in, or exiting, did commit a misdemeanor, a larceny. This is a felony that is punished by up to a maximum of 5 years and or $2,000. The court shall order law enforcement to collect DNA identification profile sample before sentencing or disposition, if not taken at the time of arrest, and against the peace and dignity of the state of Michigan.
Thank you. Sir, did you understand what was just read?
Yes, ma'am.
So you understand motor vehicle unlawful driving away count 2 is a felony punishable by 10 years, and your driver's license would be suspended. Do you understand that?
Sorry, Your Honor, I believe that's 5 years.
I'm sorry, 5 years for the count 2.
Yes, ma'am.
Okay, and then
Yes,
count
ma'am.
3, the litigation third degree, that's a 10-year, correct?
That's a 5-year.
Or 5-year also, okay. All right, and count 3, home invasion third degree is also punishable by 5 years. Do you recall that? And you understand it?
Yes, ma'am.
All right, very good. And it looks like you signed the advice of rights form. Did you read it before you signed it?
Your Honor, I signed the advice of rights and the pretrial form with my client's permission.
So the advice of rights form, it looks like your attorney signed it on your behalf, but you went over it with him, is that correct?
Yes, ma'am.
Was he able to answer any questions if you had any?
Yes, ma'am. He answered all.
All right, do you have any questions about your rights in this court?
Yes, ma'am.
Do you have any questions of this court in regard
Oh,
to your
no.
rights? Okay.
No.
And did you wish me to go over them with you again, or no, you're good?
No, I'm good.
All right, thank you. And sir, it's your intention to plead to count 2 and 3 today, is that correct?
Yes, ma'am.
And did anyone force, threaten, or coerce you to plead?
No, ma'am.
Did anyone promise you anything other than the plea agreement that caused you to plead?
No, ma'am.
You are pleading today of your own free will,
Yes, ma'am.
after talking with your attorney?
Yes, ma'am.
And you've been satisfied with the representation of your attorney?
Yes, ma'am.
Sir, as to count 2, unlawful driving away of a motor vehicle, the 5-year felony, how do you plead?
Guilty.
And as to count 3, home invasion third degree, 5-year felony, how do you plead?
Guilty.
And sir, you understand that by pleading, you're giving up certain rights and defenses you would have had you gone to a bench trial or jury trial, such as the presumption of innocence, the ability to cross-examine witnesses and evidence brought against you, the ability to hold the people to their burden of beyond a reasonable doubt, and you are waiving all of that. You understand that?
Yes, ma'am.
Including your automatic right of appeal. So if you choose to appeal, you first have to ask permission of the Court of Appeals, and it becomes their decision whether or not they will accept your wish to appeal. Do you understand all that?
Yes, ma'am.
All right, thank you. And sir, as to the restitution, if there is any, if you disagree with the amount, then you tell your attorney we'll have a restitution hearing, and I will determine the amount based on the evidence. So the amount can go up, it also can go down. Do you understand that?
Yes, ma'am.
And sir, this agreement, there is no agreement as to any jail or prison time, is that correct?
Correct, Your Honor.
All right, thank you. Has anyone told you what I will do at the time of sentencing?
No, ma'am. No.
I'm sure you went over options, but I don't even know what I'll do because I'm not fully informed, and when I'm fully informed, then I will make up my mind. Do you understand that?
Yes, ma'am.
All right. Did this offense occur on or about June 14th, 2024?
Yes, ma'am.
In the township of Meridian, County of Hingham, State of Michigan?
Yes, ma'am.
at a specific location known as 3584 Otsego, Otsego, Street in Oakland.
Yes, ma'am.
And that is not your home, is that correct?
No, ma'am. No.
So that's correct, yes?
Oh, yes, ma'am, yeah.
It's okay. So you don't have any right or entitlement to be on that property without permission of the owner, is that correct?
Yes, ma'am.
And you understood that was a home where people lived,
Yes, ma'am.
and you entered that home without permission?
Yes, ma'am. Yes, ma'am.
And what did you enter and how?
The garage, through the garage door.
Okay, and when you did enter that garage, did you take something that did not belong to you?
Yes, ma'am. Yes.
And was that a Mercedes?
Yes, ma'am. Yes.
And you understood that that Mercedes belonged to the homeowners?
Yes, ma'am. Yes.
And did you know who they were?
No, ma'am. No.
And you did not have any permission from them to drive that motor vehicle out of the garage, is that correct?
Yes, ma'am.
And in fact, you did drive it out of the garage and take it off the premises?
Yes, ma'am.
And was there any damage to the vehicle?
No, ma'am.
All right. On behalf of the people, any additional questions?
The people are satisfied, Your Honor.
Mr. Kaplan, any additional questions?
Just a couple. Mr. Joyner, at the time you were on the property, the garage door was closed?
I'm not certain. I don't fully remember.
Okay. But you entered. So there are two doors, correct? Is there like a regular door and then a sliding door?
I'm pretty certain. I don't really.
So let me ask you this. Wait a minute. Let me ask you this. Were you high or intoxicated during this time?
No, ma'am.
So why don't you remember?
It's just been a minute. It's been a long time.
I also think, Your Honor, there were several incidents that he was involved with, similar things. In any event, Your Honor, the defense will be satisfied with the court's questioning.
Okay, will counsel stipulate that he entered or put physically his body into the home residence premises of the victims?
Correct, you will.
And I believe you already asked him that, and he did agree to that, but I would stipulate to that.
All right, thank you. I think with that, we have a factual basis. All right, and so, sir, I understand you're a little fuzzy. It's been a couple of years, and there was a lot going on in your life. So what you've told me though was from your own memory, is that correct?
Yes, ma'am.
All right, and I don't remember if I asked you this, but you've been satisfied with the representation of your attorney?
Yes, ma'am.
All right, very good. And are counsel aware of promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No, Your Honor.
Does the court comply with the court rule?
You have, Your Honor.
It has.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count 2 and the added count 3 on the amended felony information will enter. Count 1 is dismissed in its entirety. Any restitution, if any, and it doesn't sound like there is any, but who knows, that will apply to this file, and we'll talk about that at the time of sentencing. Any outstanding warrants related to this file are hereby recalled and dismissed. If there was any contraband seized, and I don't get police reports, so I don't know, but if there was any contraband seized, burglars, tools, drugs, alcohol, whatever it was, those are forfeited, if any, again, I don't know. And we have a sentencing date.
August 3rd at 10:30 a.m.
Sir, probation is going to contact you. They're going to be doing a very detailed pre-sentence investigation report. We'll talk about that at the time of sentencing. Would you like to be brought here from prison, or would you like to do it on Zoom again?
I mean, we can do it over Zoom again. I'm not,
All right. I'll just
however,
make
it's
it
all
do
right.
it. I'm sorry, what?
I said, however it's done is all right.
It's just up to you. You have an absolute constitutionally protected right to stand next to your attorney. That's why I have to ask you. So if you want to be here and stand next to your attorney, that's fine. But if you want to do it like this, that's fine too.
Zoom is all right.
All right, so we'll do this on Zoom, and I've noted that. And I take it, Mr. Kaplan, you're good with that?
I am, Your Honor.
And on behalf of the people, you're good with that as well?
Yes, Your Honor, and I will take care of that writ.
Thank you. And Mr. Kaplan, you'll then spend some time with him prior to going on the record to go over that PSIR, correct?
Absolutely, yes.
All right. I doubt that there's a bond on this still, but in case there is, just to make sure all this time counts, I'm gonna dismiss the bond. And I don't know whether it counts or not, how the order of this goes, but we're just gonna make sure that happens as well. So good luck to you, sir. We will see you in August, all right?
Thank you.
All right.
Your Honor, just again, I didn't quite hear the date. Was that August 3rd at 10 a.m.?
Yes, sir. August 3rd at 10:30 a.m.
10:30. Excellent. Thank you, Your Honor.
Okay, thank you.
I'm going to handle beer and Gary next. Yes.
Send on my line, that's okay. Just in case, I'll just sign.
Should have the Julius adjudicator one.
Yeah, it's right.
Any approach, Judge?
Me. This is docket 2677FH, 262336FH, 262428FH, and like 261065FH, is that correct? All of
Correct,
those?
yes.
Okay. I see all of those files on the bond report, but I don't see the 261065 on the docket, but clearly we are dealing with all of these cases today. So stipulated despite maybe there's not notice on that on the file?
Yes, Your Honor.
Correct, Your Honor.
Thank you. All right. And sir, I didn't give you your rights yet, did I? Did I ask
You
you?
do need to ask for appearances.
Okay, appearances for the record.
Yes, Your Honor. Good morning. APA Bart Buxton on behalf of the people of the state of Michigan.
Aaron Robinson, Assistant Public Defender for Mr. Fury.
All right. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you for your hand down. Sir, have you taken any medication yesterday or today?
Say that
Have
again?
you taken any medication?
No,
Are you supposed to be on medication? You're not?
No.
Any sign of fever, COVID, or other illness?
no, ma'am.
Have you had enough time to speak with your attorney?
Yes, ma'am.
And you've been satisfied with her representation of you?
Yes,
And today, is going to be a plea today, is that correct?
yes, ma'am.
All right, and you're doing that of your own free will, no one forced, threatened, or coercion?
No, ma'am.
No one promised you anything?
No, ma'am.
All right, and you had enough time to talk to your attorney about all of these matters, is that correct?
Yes, ma'am.
All right, very good. And sir, you are not in lockup. Are you residing on Cedar Street? Your home?
No, ma'am.
Your homes, okay. And did you graduate high school?
No, ma'am.
How far did you make it?
10th grade.
Okay, and what is your line of work? I assume at your age you've been working,
No, I was getting social security disability.
but you're on SSD, okay? All right. And whatever you're pleading to, were you on probation, parole, or bond conditions at that time?
No, ma'am.
All right. Are there warrants for you anywhere else?
No.
Okay. And you're a US citizen?
Yes, ma'am.
All right, on behalf of the people, what is the plea agreement?
Yes, Your Honor, there is a global resolution in all of Mr. Gary's files. Mr. Gary will be pleading to the entirety of file number 26-1065-FH. Those being to count 1, possession of methamphetamine, count 2, retail fraud first degree, count 3, assault and battery, and habitual fourth offender status. Upon successful plea and sentencing, the people will dismiss file 26-2336-FH in its entirety, 26-2428-FH in its entirety, 26-077-FH in its entirety, and the 54A case in district court being 26-602-SM. There will be restitution on all files, even files that have been dismissed as a result of this plea. And there is an agreement to no upfront jail if the defendant agrees to inpatient treatment and or participation in the TRICAP program. However, if the defendant is not successful in that program or leaves that program, then the defendant agrees to at least a minimum sentence of 19 months in prison.
That would be completing the treatment, including all aftercare.
Correct, Your Honor.
Full, fair, accurate, and complete?
Yes, Your Honor.
Full, fair, accurate, and complete, sir?
Yes, ma'am.
So treatment, that means you can't walk out of treatment.
Yes.
Something, we hear all the time that there's problem in treatment, or you belong to someone or whatever, people have excuses to walk out. If something like that happens, you contact your lawyer, you get in front of me. Don't take it up your own, in your own hands and just walk out, because then you're walking for 19 months into the prison.
Yes, ma'am.
So I understand that life happens. Just stay there and reach one of us.
Okay.
And then we'll take care of whatever the issue is, transferring you, or get to the bottom of whatever's going on. Because I hear this all the time, there's lots of excuses why people walk out. Don't be doing that. if there's an issue, we are very capable of handling it and getting you to a different place or fixing the problem, okay? And you understand that also means any aftercare, because it's not a one size fits all, one stop problem. If you're an addict, it's a lifetime issue, and what's going to happen is they're going to give you some tools like AA, NACA, maybe some additional counseling, whatever it is. And you're gonna have to follow through with that, because if you go backwards, then again, you're going to prison. Do you understand?
Yes.
Okay, you're willing to do all that?
Yes.
Okay, very good. Council, are you waiving reading docket 2677 FH, 26, 24, 28 FH, 26, 23, 36 FH, and 26, 6025 S, or 602 SM
Yes, Your Honor.
in their entirety?
Correct.
Then as the reading of 26, 10, 65 FH in its entirety.
Thank you, Your Honor. People of the state of Michigan versus Jerry Jamar Gary. State of Michigan, County of Ingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 1, controlled substance, possession of methamphetamine/ecstasy. On or about December 18, 2025, at 201 East Grand River Avenue, East Lansing, Michigan, 48823, Ingham County, in the state of Michigan, the defendant did knowingly or intentionally possess methamphetamine, contrary to statute. That is a felony that is punishable up to a maximum of 10 years and or $15,000. Count 2, retail fraud in the first degree. On or about December 18th, 2025, at 201 East Grand River Avenue, East Lansing, Michigan, 48823, Ingham County, in the state of Michigan, the defendant did, while Target was open to the public, steal property of the store that was offered for sale at a price of $200 or more, but less than $1,000, contrary to statute. Retail fraud, second or subsequent offense notice. And in further appearing that on November 17th, 2022, said defendant is previously convicted of violating MCL 750.356D subsection 1 in the 54A District Court. Therefore, this violation of statute constitutes retail fraud in the first degree. With this subsequent offense notice, this is a felony that's punishable up to a maximum of 5 years and or $10,000, or 3 times the value/difference in price of property stolen, obtained, or attempted to be obtained, whichever is greater. To impose a fine of 3 times the value, the defendant must admit the amount, or it must be determined by the trier of fact at trial. See case law. Court may order reimbursement to state or local government for expenses incurred in relation to the incident, including but not limited to expenses for emergency response and prosecution. Count 3, assault or assault and battery. On or about December 18, 2025, at 201 East Grand River Avenue, East Lansing, Michigan, 48823, Ingham County, in the state of Michigan, the defendant did make an assault or an assault and battery upon the following person: Timothy Russell Hayden, contrary to statute. This is a misdemeanor that is punishable up to a maximum of 93 days and or $500, and a consecutive sentence may be imposed under statute if the assault was committed in a place of confinement. There was also the habitual fourth offender status, which the people filed a notice of intent to seek. Take notice that the defendant was previously convicted of the following felony offenses or attempting to commit the following felony offenses. On or about April 30th, 2025, they were convicted of the offense of felony controlled substance possession, cocaine, heroin, or another narcotic in violation of MCL 333.7403 2A5 in the 30th Circuit Court for the County of Ingham, State of Michigan. and on or about September 25th, 2023, they were convicted of the offense of felony controlled substance possession, cocaine, heroin, or another narcotic in violation of MCL 333.7403 2A5 in the 30th Circuit Court for the County of Ingham, State of Michigan. And on or about April 13th, 2022, they were convicted of the offense of felony controlled substance possession, cocaine, heroin, or another narcotic in violation of MCL 333.7403 2A5 in the 30th Circuit Court for the County of Ingham, State of Michigan. Therefore, the defendant is subject to the enhanced penalties provided by MCL 769.12. That penalty being life if the primary offense has a penalty of 5 or more years, or 15 or less if the primary offense has a penalty of under 5 years. The maximum penalty cannot be less than the maximum term of conviction. That would make count 1 a life offense. That would make count 2 a life offense. And that would keep count 3 the misdemeanor as is.
Thank you. Sir, did you understand what was just read?
Yes, ma'am.
So you understand count 1, controlled substance possession or controlled substance known as methamphetamine, ecstasy, is a felony normally punishable by 10 years, but it is now, because of the habitual fourth, enhanced up to life. Same with retail fraud, first degree count 2, which is normally a 5-year felony, but because of the habitual fourth statute, it now is also punishable by up to life.
Yes, ma'am.
And then the assault or assault and battery is a 3-day misdemeanor. You understand that?
Yes,
And there's restitution that would transfer from all files onto this one. However, you're entitled to a restitution hearing. If restitution is actually being sought and you disagree with the amount, you let your attorney know, we'll have a restitution hearing. And then after the hearing, I'll make up my mind as to whether or not the amount that's requested stands. It can go up, it also can go down. Do you understand all of that?
Yes, ma'am.
And it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes.
Did you understand what you read?
Yes,
And
ma'am.
if you had any questions, you were able to ask those of your attorney?
Yes.
All right, and it's fair to say that you are going to be pleading of your own free will?
Yes, ma'am.
No one forced, threatened, or coerced you to plead?
No, ma'am.
And no one promised you anything other than this plea agreement that's causing you to plead?
No.
You've chosen to plead after you consulted with your attorney,
Yes,
and
ma'am.
you've remained happy with her?
Yes.
Thank you. Sir, as to count 1, possession of a controlled substance known as methamphetamine/ecstasy, how do you plead?
Guilty.
As to count 2, retail fraud, first degree, how do you plead?
Guilty.
As to count 3, assault or assault and battery, how do you plead?
Guilty.
And sir, at the time of these offenses, were you high?
Yes, ma'am.
Do you still remember what happened of your own memory? Or are you remembering this from conversations with your attorney, police, or the police report?
No, I was intoxicated.
But, so do you remember a recollection what happened or not?
No.
Okay, so that being the case, do you use a no contest plea rather than that and use this, or? I mean, if he's high, which I have every reason to believe, given his history.
The people would have no objection to a no contest plea, Your Honor.
That's fine, Your Honor.
All right, so we're gonna change this to a no contest plea, and the reason for that is, sir, a no contest plea, it acts as a guilty plea, but it really lets me use a police report, which I don't otherwise have, to form what we call the factual basis on these counts, because I have to make a record of that there's sufficient evidence on each count against you, and I can use the police report rather than you telling me you don't remember. So it will have the same effect as a guilty plea, but it's no contest based on lack of memory. Do you understand that, or would you like some more time with your attorney?
No.
All right, so you understand what I'm gonna be doing then?
Yes, ma'am.
Okay, so then I'm gonna re-ask you how you plead, and the answer will be no contest based on lack of memory, okay? So as to count 1, possession of a controlled substance known as methamphetamine/ecstasy, how do you plead?
No contest.
And as to count 2, retail fraud, first degree, how do you plead?
No contest.
And as to count 3 assault or assault and battery, how do you plead?
No contest.
All right, thank you. Court is satisfied that we should proceed that way and take it. The council has a police report for
I
me.
do, Your Honor, can I approach?
Yes, so stipulated.
Yes, Your Honor.
Thank you.
And Your Honor, in reviewing the police report, I do see that the date on the information was incorrect. It should be December 12th.
Okay.
The people can do an amended information with that new date.
Well, you have to do, oh no, I guess you don't have to do an amendment, but yes, you should do an amendment as to that date. So you're still stipulating as to the date?
We will.
All right, very good, then we can proceed. And sir, as I said earlier, you understand you're giving up your right to a bench trial or jury trial, presumption of innocence, and holding people to their burden of beyond reasonable doubt.
Yes, ma'am.
All right. And should you violate the law between, or bond conditions between now and sentencing, I understand I don't have to follow this plea agreement.
Yes, ma'am.
Okay. Court has been handed the East Lansing Police Department case report number 2536403679. The report date and time is December 12th, 2025. I have amended the felony information, will provide an official amended felony information that reflects the date of December 12th, 2025. It reflects the approximate time, at least, that police responded of 6:17 p.m. The specific location is 201 East Grand River Avenue, and I'm changing the alleged date to the 12th on all 3 counts, as well as above in the bracket of the felony information to reflect the 12th. And it appears from this, it was 201 East Grand River Avenue on the 12th of December, 2025, in the city of East Lansing, County of England, state of Michigan, at that location. And at 18:13 hours, officers were dispatched to that location, the Landmark Apartments, for 3 unhoused males in the lobby area smoking an unknown substance in a pipe. The suspect was a black male, 40 years old, gray hoodie. There was a second suspect in a blue hat and a black jacket, and then suspect 3 was a black hat and a black backpack. And it appears that officers caught up with one of the suspects in the median in between the westbound and eastbound Grand River Avenue, and instructed the male, later identified as defendant before this court, Jerry Gary, to stop and place his hands behind his back. And when he instructed Gary to place his hands behind his back, he stated he didn't do anything. And officer asked if he paid for merchandise, and he did not respond, and then he was handcuffed. And while defendant was walking to target, while the, yes, I guess it was defendant, to target, he stated the victim had attempted to grab the basket out of his hand several times. He also stated he did not pay for merchandise. Okay, so I think I understand that. The officer then conducted a search incident to arrest defendant Gary and found 2 crack pipes on his person inside his pockets. Officers made contact with the victim Hayden, Hayden, who stated defendant Gary had been trespassing from Target, but was not given a trespass letter. He did walk out of the store without paying for the merchandise, and then he called the police and saw him. The victim stated he attempted to grab the basket from defendant, and defendant shoved Haddon away. And Haddon was provided the stolen merchandise from law enforcement. The stolen merchandise included 2 Remington hair straighteners, $31 each, Revlon hair straightener, $37.99 each, 2 Conair hair straighteners, $21 each, and Revlon hair dry brush, $64.99. The total was $208.18 without tax. With tax, it would be $220.67. The officer did upload the footage of the retail fraud and Target incident report. Officers confirmed Gary's identity. They also then conducted a second search of the defendant before placing him in the back of the vehicle. And he was asked if he had any narcotics on him, and advised if he brought narcotics inside the jail, it would be another charge. He said he didn't have any. And they had a whole conversation about this. And then while officers were searching Gary, a bulge was felt in his left jean pocket, which defendant advised were quarters. And he still didn't admit to having narcotics on him. He had several layers of clothing, and the officer was unable to strip off all the clothing. And then he was moving around in the back seat during the transport and took off both his shoes. From the car camera, defendant could be seen using his foot to dig into his pants from the ankle. He then removed his sock and continued to dig around. Once they arrived at the jail, officers noticed his property was scattered in the back seat, which included cash, his sock, and his hat. They went on to conduct another search in the jail while he was handcuffed. And a small baggie slipped out of defendant's buttocks and landed on the jail floor. The baggie contained white powder with some small crystal rocks suspected to be crack cocaine. The narcotics were inside the corner of a plastic sandwich bag that was twisted and tore off. The bag was open and exposed. Photographs were taken of the suspected crack cocaine. The total weight of the crack and plastic bag is 6.2 grams. Was this confirmed as crack or meth?
Yes, Your Honor, and I apologize, I did not have a copy of the lab report. This was sent to the MSP labs, and that lab report was provided to defense. That substance being identified as methamphetamine.
So stipulated?
So stipulated.
Okay. And stipulated that methamphetamine is not something you would have a prescription for, and it is illegal, unlawful to possess, correct?
Correct.
So stipulated by the people?
Yes, Your Honor.
Thank you. And then it does indicate in this report that it's more than $200 property that he took. And then there is, I believe I read about the assault. So I think we've got everything covered unless you want something else, right?
Your Honor, we would stipulate also that he has been previously convicted of a retail fraud.
Thank you. And you are stipulating that he was convicted of the offense of felony controlled substance in the 30th Circuit Court in violation of the statute on or about April 30th, 2025, and then on or about September 25th, 2023, the offense of felony controlled substance possession in the 30th Circuit Court, and then felony controlled substance on or about April 13th, 2022, in the 30th Circuit Court. So this would be so the fourth habitual is appropriate. So stipulated.
So stipulated.
Yeah, people.
So stipulated, Your Honor, thank you.
Would you like to report back?
Yes, please, thank you.
All right. Our counsel, where promises, threats, or inducements other than those already placed on the record.
No, Your Honor.
No, Your Honor.
Is court complied with the court?
You have, Your Honor.
Yes.
Thank you. I find defendant's plea of no contest to be appropriate based on lack of memory as a significant substance abuse history. The plea is also wise, given that significant history. Therefore, I find that his plea of no contest is not only appropriate, but freely, voluntarily, knowingly, and understandingly made without under influence, stress, coercion, or promises of leniency. I also find, based on the police report and on the stipulations of counsel and the correction in the felony information, which will be amended, that there are sufficient grounds to accept defendant's plea. Therefore, counts 1 and 2 and 3 with habitual 4th shall enter. And as to dockets 26, 77 FH, 26, 2428 FH, 26, 2336 FH, and 26, 602 SM are hereby dismissed in their entirety with the exception of restitution that will be transferred over to this file, if any. And any outstanding warrants on all files are hereby recalled and dismissed, if any. All contraband is hereby forfeited. What is the sentencing date?
August the 3rd at 11 o'clock.
All right, certainly to cooperate with probation, they're going to.
I'm sorry, Judge. Can we get a later date? August 3rd doesn't work for me.
All right, what's the next date?
The next date will be August the 6th.
Does August 6th work? Or you know that?
Wait, Judge.
Okay.
The August the 7th at 9:30.
So August 7th at 9:30 works for you?
I think that's a Friday. Might be in 54A for preliminary examinations.
Okay, how about a couple of weeks at the end of the month? It's not gonna make any difference in this case.
The next available date will be September.
Okay.
Okay.
September what?
September 9th at 11.
Is September 9th at 11 work?
Yes, Your Honor. Thank you.
So September 9th at 11, you'll be sentenced. Now, what I'd like to do, if there's no objection, is see if we can get him into TRICAP or other residential treatment that is appropriate for meth, so we can start now instead of waiting.
Yes, Your Honor, we were going to be asking that.
All right, so is that all right with you, sir? Is that a yes?
Yes.
So what that will mean is if you are in residential treatment, we can either zoom you in or we can have you brought for sentencing, so you can stand next to your attorney, which is your right. Would you like us to zoom you in or bring you here?
Zoom in.
Okay, so people will take care of that. And sir, what I'm going to do is sentence you at this point under bond conditions, I suppose. It'll have to be to, once there's a bed, I'm gonna give you a $50,000 PR bond upon a transfer to long-term residential treatment for meth. Okay. And we've talked about those parameters. You must comply with all of that treatment, including aftercare, and then we'll zoom you in for sentencing. If you change your mind on that, you're gonna come here personally, let me know.
Okay.
So I'm also ordering that you comply with probation for the pre-sentence investigation report. And you'll appear for the next court date via Zoom. September 9th at 11 a.m. Additionally, sir, you'll need to sign all necessary releases so that your attorney in the court can know what you're doing. We're never going to end probation. We're never going to ask what you're talking about in therapy, the treatment, but we do want to know if you're complying, getting out of bed, participating, doing what you're supposed to do, okay? Does that make sense to you? Yes?
Yeah.
Is there anything else I need to order?
The only thing, Your Honor, and it's not in regards to orders specifically, I would just ask if the people are the ones to set up the Zoom for the sentencing, if the defense could just let us know where he's located at when he does get a bed available. We can look into that at that point, but we'll just need to be updated on where exactly he's at. Besides that, the people have no issues, Your Honor.
Okay.
Also, Your Honor, it looks like on this file, the 26-1065 file, it's set for a final pretrial on August 26th. So it will obviously be taken off the docket.
Yes, thank you for reminding us about that. Okay. Do you have any questions, sir? Okay, good luck to you.
Thank you.
We'll make sure you get copies. We kind of, I wrote it there.
We can, but it's 12:30, so I'm
Only
only court transfer.
Oh, okay.
Your Honor, it is 12:25. I'm not sure if the court wishes to take a break at this time.
Well, that's up to Nancy, so, I should probably take a break, but how much more do we have?
We have 1, 2, 3, 4, 5 other cases this morning.
Okay, because I also have weapons court, so we can take a break and then, return, but we gotta. So is there anything that's, what about the,
I have a quick bench warrant right now.
Okay.
That makes a difference. Blacksmith?
Are we doing that now?
I don't know.
It doesn't matter, it's up to you guys.
We can, let's just try and take a break, Nancy.
I got a potty.
Yeah.
Okay, we'll return shortly. Thank you.